So welcome everyone. So we were doing Bhartiya Sakshya Adhiniyam. So we were just left with only two parts of the relevant facts, of relevancy of facts. So by that we will be finishing our first part of this Adhiniyam, and we will move to the second part of Adhiniyam, that is dealing with what type of evidences you can give before the court. So in that head we will be studying oral evidence and along with documentary evidence. So as of now we will be dealing with the second last topic of relevancy of facts, and that is opinion of a third person or of a person who is an expert having some degree or some qualification in relation to his particular field or particular subject. So what does opinion mean? Opinion means your prediction, your analysis, deep analysis on the particular information, on particular data or a particular behavior or any conduct, and that person analyze your data or any conduct or any type of information, and he gives his result on the basis of applying his calculations and all his scientific methods, having some experience or having qualification or having any kind of degree in that regard. Opinion ਕੀ ਹੁੰਦਾ ਵਾ? That is अनुमान. अनुमान किहदे बेसिस ते लगदा? That on basis of any कोई भी सूचना होवे, कोई भी साधन होवे या कोई भी अपना ह्यूमन पैटर्न होवे, ह्यूमन बिहेवियर होवे, एंड ਉਹਦੇ ਉੱਤੇ ਡੀਪ ਐਨਾਲਿਸਿਸ ਕਰਕੇ, ਉਹਦੇ ਉੱਤੇ ਡੀਪ ਸਟੱਡੀ ਕਰਕੇ on the basis of your strict standard procedures or strict scientific methods, then you give your own opinion. Then that fact, which is the opinion of that person, it can be a third person or it can be a expert person, that we will be studying what's the difference between opinion of the expert and opinion of the third person. So as of now, so we will be studying the opinion of expert persons. So who are experts? Expert is a person who has some kind of qualification in form of a degree or in form of any diploma from any institution, or it can be any person who has a particular experience on the basis of number of time period or number of years or any particular time period. So he has experience in relation to particular substance. So then that person can be considered as expert person. So कौन आ सकते हैं expert persons दी category च? It can be a medical expert, it can be forensic expert, or it can be ballistic expert who provides information relating to the firearms, or it can be any blood sample expert person. So there are a lot of categories in expertise. The person can have expertise in any field. So expertise can be judged on the basis of his qualifications, his degrees, or number of years in that experience. So section 39 of Bhartiya Sakshya Adhiniyam, which deals with the opinions of experts, it states that when the court has to form an opinion upon a point of foreign law or of science or art or any other field. So any other field, which means it is a residuary section. So field can be any, it can be relation to chemistry, biology, or physics, or any. And this is the new thing which is being added under Bhartiya Sakshya Adhiniyam, point of foreign law, which was not available under Indian Evidence Act. So you have to keep this thing in mind. So this is the amendment, or you can say this is the new change. So foreign law, any point based upon foreign law, if court wants opinion in that regard, so court can call experts. So after that, as to identify any handwriting or any finger expressions, so the court can get the opinion upon that point of persons specially skilled in such foreign law, science or art or any other field, or in questions relating to identity or handwriting. So you got my point. And now what is becoming relevant here? The opinion given by that skilled person. Skill can be based upon, it can be based upon your qualifications, your degrees, or your experience. That can be any number of years. So the opinion given that by a skilled person will become relevant in relation to point of foreign law, art, science, or any other field, or to identify any fingerprints or type of handwriting of a particular person. So there are number of experts who can judge the handwriting based upon comparison analysis, so as to know whose person's writing is this. It is mostly used in civil cases, in execution deeds, when any particular signature is in question. So the court has luxury of calling the expert persons who have expertise in identifying the handwriting based upon different methods. But keep this thing in mind, this is only a relevant fact. The opinion of that person who is a skilled person will be of relevant nature, but it is not of a conclusive nature. The opinion of that expert person will not be bound upon the court. So the court has to apply his own mind based upon the expert's opinion and other evidences proved by the parties in order to prove their particular point. ठीक है जी? So the opinion of the expert person is not of conclusive nature. So section 39 subsection 2, it deals with the electronic experts. When in a proceeding the court has to form an opinion on any matter relating to an information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79A of Information Technology Act is relevant fact. So in relation to any electronic document, the opinion of the examiner of electronic evidence will also be a relevant fact. So what type of opinion can examiner of electronic evidence can give? Whether any particular electronic or digital form of document is tampered or not. So there can be a lot of points of determination in relation to a digital form of document. The questions can be when it was last amended, or it is tampered or not, in whose possession it has been found. So there can be a lot of points. So the opinion given by that examiner of electronic records will be of relevant fact. So for that purpose, the examiner of electronic evidences will be considered as expert person. So expert दी कोई particular definition नहीं ਦਿੱਤੀ गई है. So expert can be any person who is equipped with any skill. Skill can be based upon your qualifications or your experience. So let's proceed further. Section 40. It states that any fact which is not otherwise relevant, if they support or they are inconsistent with the opinions of the expert, and that opinion of that expert is relevant fact, and that fact जो ਉਹਦੇ against ਆ ਜਾਂ ਉਹਨੂੰ support ਕਰਦਾ ਵਾ, that fact will also be of relevant nature. ठीक है जी? So ਜਿਹੜਾ opinion expert person ਦਾ relevant ਹੋਊਗਾ, ਜੇ ਉਹੀ expert opinion ਨੂੰ ਕੋਈ fact ਆ which is not otherwise relevant under this adhiniyam, but that fact is supporting the claim of opinion or it is inconsistent with that opinion, then that particular fact, even though it is not otherwise relevant under Bharatiya Sakshya Adhiniyam, if it is supporting or it is inconsistent, then it will become relevant under section 40 of the Bharatiya Sakshya Adhiniyam. ठीक है जी. So let's take an example of this section 40. The question is whether A was poisoned by certain poison. The fact other persons who were poisoned by that poison exhibited certain symptoms which experts affirm or deny to the symptoms of that poison is relevant. So for example, there is a case of murder by poisoning. So A is accused who poisoned B which caused death of B. So ਇੱਥੇ question ਕੀ ਆ ਵੀ ਕਿਹੜੀ poison ਦੇ ਨਾਲ B ਦੀ death cause ਕੀਤੀ ਆ. So point of determination is that to find out the type of poison by which A has murdered B. ठीक है जी. So ਇੱਥੇ ਜੇ if the same poison is also being used in another circumstances or at other incidents, ठीक है जी. ਇੱਥੇ ਸਪੋਜ਼ ਹੁਣ ਐਕਸਪਰਟ ਦਾ opinion ਲਿਆ ਜਾਊਗਾ ਨਾ ਵੀ ਕਿਹੜੀ poison use ਕੀਤੀ ਗਈ ਆ. So under section 39 expert person will be called who will have his look at types of injuries or types of the signs caused by the body while reacting that particular poison. So the expert will form his opinion by applying his skills. So ਇੱਥੇ ਉਹ ਆਪਣਾ opinion ਦੇ ਦੂਗਾ that particular poison is being used to kill B. So ਹੁਣ ਇੱਥੇ section 40 ਕਿੱਦਾਂ relevant ਹੋਊਗਾ. ਇੱਥੇ ਜੇ in previous incidents same poison is being used to kill any that particular person, ਜਿਹੜੇ ਉਹ deceased person ਨੇ ਆਪਣੇ symptoms ਜਾਂ ਕੋਈ ਵੀ signs ਦਿੱਤੇ ਹੋਣਗੇ body ਨੇ, those facts ਜਾਂ ਤਾਂ ਉਹ ਐਕਸਪਰਟ opinion ਨੂੰ ਅਫਰਮ ਕਰਨਗੇ ਜਾਂ ਫਿਰ ਉਹਨੂੰ ਡਿਨਾਈ ਕਰਨਗੇ. So that symptoms, even though they are not relevant facts, so if they support or deny the opinion of the expert, then those facts will become relevant under section 40 of this adhiniyam. ठीक है जी. Section 41, it deals with the handwriting and signature. When court has to form opinion in relation to any particular handwriting or particular signature, where point of determination is that whose handwriting or whose signature is that on particular document, then the court can take opinion of the person acquainted with the handwriting of that person or signed by that particular person. So court ਇੱਥੇ ਉਸ ਬੰਦੇ ਦਾ, so this is the opinion of third person, not of expert. So the court can take the opinion of that particular third person who has seen someone writing in front of it, or he is acquainted with the writings of that particular person. Then the court can take opinion of that third person to identify the writing which is in question. ठीक है जी. ਇੱਥੇ ਦੋ ਤਰ੍ਹਾਂ ਦੇ third persons ਹੋ ਗਏ. First one who has seen that particular person in question while writing, and second person the person who is acquainted with the handwriting, like he has not directly seen that particular person while writing, but he has seen his writings or documents which he has received during any course of business or any kind of other proceedings. So if he has seen the writings, or if he has seen the particular person in question directly writing in front of him, then the opinion shared by that third person will be of relevant nature. ठीक है जी. So let's begin further. Section 42, which deals with opinion in relation to general custom or right when relevant. When the court has to form an opinion as to existence of any general custom or right, the opinion as to existence of such custom or right of persons who would likely to know of its existence if it existed are relevant. So if there is a question in relation to existence of any right or any custom, So any person who is equipped with the knowledge in relation to the existence of that particular custom or particular right, then opinion of that person will be of relevant nature. So same is thing in section 43, which deals with the any usages or any rules in particular family or in relation to any charitable foundation. If the question is in relation to governance and constitution of any religious or charitable foundation, or in relation to any particular terminology used in particular district or any particular by any particular class of people. So any person who has a special knowledge in relation to that particular terminology or any rules and regulations